what the police were interested in, first and foremost, was to do things the right way and to do it by the books. We did not want to have any misstep in the investigation. We didn't want to blunder with the investigation. And it is not unprecedented that a person is kept in custody after an accident. This has been done before. The police would normally issue NIP in circumstances where it is difficult to ascertain what may have occurred on the scene. So the police investigation process will take a little while longer. So the police would normally do that. But where, from the police investigative view, they are of the belief that a certain person may have been at fault, the police can proceed and prefer charges immediately without issuing an NIP. And in this case, that is exactly what we did. And Mr. Noble, I can tell you, was not singled out because he is affiliated in any political party. And he understands what is it that we were doing. I explained to him the process. And I must say that he cooperated in terms of how he was, his entire behavior towards the investigation as well as at the police station.
Sir, are your officers able to say he refused to give a specimen? His attorney said today for religious reasons. Are you able to say if your officers perceived that Mr. Noble appeared intoxicated?
I don't know where Mr. Panton normally gets his things from, but that is his defense. The law does provide that the police may request blood or urine specimen, and that was done. So even if, as Mr. Panton is saying, for religious reason he did not want to extract blood, religion does not stop you from peeing, right? And that's the alternative that we have other than extracting blood, and both processes were refused by Mr. Noble in relation to the investigation.
Did he appear inebriated or to be under the influence?
I was on the scene. I'm not a doctor. I cannot say whether or not he was drunk or as the case may be, but I can say that he spoke well, but being actually drunk and being legally drunk is two different things.
But you will not be able to determine if he was legally drunk if he did not give a specimen.
Exactly.
Was he given special treatment insofar as was he allowed to not be in the detention cell but to be in an office at the Raccoon Street Station?
While, yes, he may not have been kept in the cell block, he was kept at the police station, not in any office with no other special treatment. So to answer your question, I will say yes, and that was a discussion that I made being the person in charge of my station, considering the fact that it's an accident, it was not an intentional killing, and it's an unfortunate situation that anybody could find himself in at any given time.
So now his defense has demanded disclosure by the next court date. Will you all be able to meet that?
I could understand Mr. Panton's plight in wanting to get disclosure, but the criminal practice and procedures rule are very clear. And I am sure that when that time comes, if the police do not have the disclosure ready, the prosecutor will be able to argue before the court, using the rules of the court, that where indictable matters are concerned, disclosures are to be given within 14 days of the preliminary inquiry. That is clear in the rules. That does not prevent the magistrate from ordering the police to give disclosure earlier. But where that is done, the police can then go to the court and argue that, Your Honor, we have not been able to provide the disclosure because XYZ, the preliminary inquiry date is not upon us. And again, as it relates to production of the case file, the rules are also clear. It must be done within or after, no later than 8 weeks. So there is sufficient time that the police have to be able to investigate properly, so that when we do give disclosure, we give the proper disclosure that we should give.